Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend and special guest, Russ Cook of Russ Cook and Associates over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney, and yes, that's all he does is estate planning. So this is important for you. All right, you get into, there are a lot of attorneys out there, and some do a general practice where they may handle, wear a lot of hats, let's say, which is fine. And if your plans are really, really simple and you don't need that same expertise, that may work out just fine for you to just do a simple will. But if you really need or want that expertise that goes with 30 years of experience doing just estate planning and the tax issues and charitable foundations and all the different things that Russ can get into, including keeping up with trust law. All right, and this is one of the areas I was talking about just before the break, is understanding that these laws change. I mean, there are different things that happen in the world. Tax changes that can, tax law changes that can affect you, the investment landscape, as we've talked about, and of course estate planning is one of those as well. So Russ, one of those developments over the last, whatever it's been, 3 to 5 years, I guess, is this of community property trusts.
Yes, yeah, Tennessee, his legislature has given us many, many gifts in the estate planning arena. One is the community property trust, and to describe it is to start with the income tax issues involved when you pass away. When you pass away, any assets that you own get what's called a step up in cost basis. What that means is if you bought a stock for $10 and it's worth $20 when you pass away, that cost basis, what you paid for it, gets stepped up to the date of death value. Why is that important? Well, if your heirs later sell that stock for $20, knowing that you had that cost basis step up, they will pay no capital gains tax on that sale. Whereas if there was no step up in cost basis and you bought a stock for $10 and sold it for $20, you'd be paying capital gains tax on that extra $10 that's involved there. Now, the problem that we ran into in Tennessee is we're what's called a common law state, or a state where there's no community property interest. Aside from what that really means as far as comparing state laws, we look back to the cost basis issue. If a husband and wife own an account, and let's say they bought the stock together and they paid $10, and then one of them dies and the stock's worth $20, you're only going to get a cost basis step up on the decedent's half. So that means if the survivor sells the stock, they would be paying capital gains tax on their share of the capital gain. Well, if you take this same stock and put it into what's called a community property trust, which is simply a joint revocable trust between husband and wife, then when the first spouse dies, not only does the decedent's half share get a cost basis step up, but the survivor's half share gets a cost basis step up too, even though the survivor is still alive. So what it does is it allows us to reset that cost basis on capital gain assets in the entirety and allow the survivor to reposition assets if they need to sell them or whatever, and not pay hardly any capital gains on the sales.
This is one of those areas when it comes to capital gains tax. We were talking about tax planning as part of the of having a good financial plan, a good comprehensive plan. You can see how it ties in also on the estate planning side. So if you understand the difference here, to give you an example, when I talk about tax efficient income in retirement, we look at ways that we can pull money out of your retirement accounts, but also utilizing other resources that may be available to help manage your taxes. So an example would be if you're making, or let's say your income needs are over $100,000 a year, that you're going to need over $100,000 a year, and let's just pick a number like $120,000 as an example. So if you need $120,000 a year to cover your expenses, all right, to maintain your current standard of living and quality of life, then when you're crossing that threshold of 100,000, it's about 104 exactly, but when you cross that for a married couple over age 65, you're crossing from what today would be a 12% tax bracket over into a 22% tax bracket. So just besides the fact you're almost doubling your taxes, okay, that you're going to pay on that $20,000. So that means on the 100,000, right, you're capping out that 12% bracket, and your effective tax rate, because of the progressive nature of our tax system, is about 9% on that 100,000. So you're going to go from a 9% tax rate on that 100, and then bump up to a 22% tax on that 20,000, right? In my example, that is exceeding the 100. So think about that. Instead of paying on 20,000 in under 100, your total tax, based on that tax rate, was only going to be about $1,800, and you're going to go to $4,400. From $1,800 in taxes, $4,400 in taxes. Which would you rather pay? Easy question, right? Easy answer. So to do that, though, how do you think, well, but if I need 120, and this is where, if we're going to manage your income in such a way that we can get your taxable income and keep it under 100 while still giving you the income you need of 120,000. We can do that if you've got the certain resources. So if you've got non-qualified funds, Roth IRAs, different ways, and if you're not structured that way right now, we can help you. Potentially get in that type of a situation where you have some funds that are not in your IRA that can be used for income. But it's understanding how these work. A lot of times people just do I was talking to my Vanguard rep just the other day, and one of the things that we got into was the studies that Vanguard does, showing how people typically pay so much more in taxes simply because they don't understand the tax code, and they don't really sit down and have someone that can help them do up a plan. All right, where they can plan to minimize taxes in retirement when they're taking that income. Typically, they just start using up the taxable dollars, thinking, I want to take tax deferral as long as I can, right? Thinking that's the advantage. But the reality is, even though you may pay less tax initially, you end up paying a lot more tax over the long term. And what we want to do is reduce taxes, not just this year. And this is the other part, by the way, if you're leaning on your accountant to do it, they typically are just looking at this year. What I can do to reduce your taxes this year, not worrying about 5 or 10 years down the road, or at the time when you're taking required minimum distributions, for instance, how that's going to affect your taxes, and how you can do some planning today where you maybe pay a little more now to pay a lot less later, overall reducing your tax burden over your lifetime. This is the kind of planning. See, it's a longer term view, just like with estate planning. When you're getting into estate planning, we're talking about the long view, not just, even more so, not just during your lifetime, but what happens when you're gone and what you want to have happen there, and how to minimize taxes. So I mentioned that threshold, right? 100,000. Not only is this 100,000, you're jumping from a 12 to a 22% bracket. And by the way, when the tax law sunsets, the provision in there, it's going to go 15 to 25. All right. So not only that, but capital gains. This is a significant threshold as well, because once you cross over that 100,000, including the gains, right, now you're going to be paying a 15% tax, where if we can keep you under 100,000, it would be zero tax. Zero is good, right? Wouldn't we like to pay zero tax instead of 15? Imagine that if you had using my example, about 20,000. So that means $20,000 in gains, right? Zero tax on it versus $3,000 in taxes. We just want to keep putting those tax dollars back in your pocket through good planning. There's no requirement that you pay more than you're legally required to pay. All right. In fact, it's foolish to do so, but mainly it's done. People just don't know, and we're going to help you know how to do that. So as Russ was talking about with the community property trust, this is another way in your estate planning that you can help minimize taxes in the future, open up some opportunity to take advantage of these laws. Again, if you want to be one of the first 10 callers to my office this morning, we can give it to you one more time, 615-376-5325. If you'd like to get this kind of planning, if you'd like to see how you can benefit from this, how you can minimize your taxes, get your estate planning in order, and of course this is your financial life. I can show you based on the things we're going to need from you, all right? We're going to look at your income again, expenses, assets, liability. We're going to calculate in for taxes, for factor in inflation, rates of return on your money. What's the needed rate of return? Do you even know how much you need to make on your money to accomplish your financial goals? I can show you what that looks like, and I can show exactly what it would be, in fact, what that number needs to be for you. And this is important. I'm going to explain this in a moment as well. But I can also then show you your financial future. I can show you what your assets are going to grow to over the next 5, 10, 20, 30 years or more. All right, so you can see, are you going to be okay? Are you going to be able to do all the things that you want to do, attain and maintain your standard of living and quality of life, no matter how long you live, and share strategies with you to make sure you don't have to worry about running out of money. So again, 615-376-5325. Tess is standing by. She'll get your information. She'll send you out a packet of things to bring to your appointment with me. And when you come in to see me, I'll give you a free copy of my book, 7 Steps to Financial Freedom and Retirement. And we cover all the different factors in there as well. All right. You know, one of the things when it comes to planning, and we can go, yeah, thanks. When it comes to planning, and we're thinking again on the estate planning side, and as I mentioned, you know, be one of those to come in. You'll get a free consultation with Russ, and Russ, you usually charge, what is it, $400 to do a consultation. So nice value, right? Take advantage of it. Get another look at those estate planning documents and see if there's some ways those can be improved, and take advantage of maybe this community property trust example that Russ was using. And then there's the asset protection features. You know, some other changes that have happened. So if it's been 10 years or more since you've done your estate planning, it may be that when it came, looking back now, one of the changes was a Supreme Court ruling regarding inherited IRAs, and that there's pending legislation that could put these at risk even further, even for spousal IRAs, which is really going to be crazy.
Yes.
So the key of it is this. What it means is that asset protection, right, the ability, so think of it this way. You want to leave your children, all right, your assets, including your retirement accounts, your IRAs, 401ks, that kind of thing. Well, you have certain protections under the law, state and federal laws, that help protect your retirement accounts. However, when it's an inherited IRA, okay, non-spousal in particular today, non-spousal inherited IRAs do not receive that same protection and could be at risk. So if you want to make sure that when you leave things to, leave your stuff, if you will, to your children, that it's going to stay with them and onto your grandchildren, stay in that bloodline. Right? So if they're married, an example, if they're married and they go through a divorce, unfortunately all too prevalent, all right? So when that in-law becomes an outlaw, we want to make sure they're not walking away with the money you've left them, right? Well, that's where this good estate planning can come in. And Russ, this is one of those areas with asset protection. It's kind of unique. Setting up this revocable trust, community property alike. The community property has some added even for the couple potentially when the first dies. But even beyond that now, the going to the next generation, the asset protection that they can provide their children that they can't actually provide themselves.
That's true, that's true. All of our estate planning these days seems to be focused on not only the income tax side of things, but also the asset protection side of things. And what we're worried about is when an asset is inherited by a beneficiary, whether it's a surviving spouse or a child, that now is the child or surviving spouse's asset that is exposed to creditor claims or ex-spouse claims or government claims that may come up during that person's lifetime. And it doesn't have to be that way. What we do is when we set up an estate plan, we'll provide, and I'm going to use married couple as an example, we'll start out with a community property trust, and that basically carries them through till the first spouse's death. And then the community property trust creates a separate trust with the decedent's half share of the estate that benefits the survivor, with the survivor as the trustee and the survivor as the beneficiary. The difference between this separate trust that's created in the original document and just giving the assets outright to the survivor or keeping them in a revocable trust means that the assets in that decedent's trust are protected during the survivor's lifetime. So if the survivor gets remarried and divorced, or let's say comes under the undue influence of some third party, you've got this pool of assets that are going to pass on down to the kids. Because one of the things we're seeing in estate administration is the unintended disinheritance of the children due to the actions of the surviving spouse. And it's not that they're doing it nefariously, it's just that it just happens that way. So what we're doing is creating a protective wrapper around the decedent's half share of the trust estate. The survivor's the trustee, survivor's the beneficiary. They can pull out as much or as little as they want. It's just not exposed to those third-party creditors and ex-spouses and government claims. then, when the surviving spouse dies, the same agreement, again, we're sticking with the community property trust, will then create separate trusts for each of the kids. So you're not giving the assets outright to each child. Why? Because when they receive it, then if they get in creditor problems or end up in a divorce or run into government problems, those assets are now exposed to their creditor claims. So what we're doing is we're continuing the idea of managing the assets through a trust, but we're allowing it to pass on down to the kids in the same manner. So now you have a separate trust for each child. The child is the trustee, the child is the beneficiary. They can take out as little or as much as they want out of the trust assets, and then when the child dies, it passes on down to their children, your grandchildren. Again, not getting sidetracked down other family lines, it sticks in your bloodline. And the children have complete access and control over those trust assets. If you're talking about minors, let's say that you have a third party step in and be trustee until the children get to a certain age, and then they can become their own trustee. So instead of giving it to them at a certain age, 30, 35, whatever, you just provide that at that age, the child then takes over the job of trustee. They're trustee, they're beneficiary, take out as little or as much as they want. They leave in whatever they leave in the trust is protected from their creditor claims. And we found that this has been a very approachable way of handling estate planning, and all of our clients, or a lot of our clients, have really benefited from this and are happy that we put this into their estate planning documents.
Yeah, imagine if you think of a trust as being like a safe in a sense, all right? Mm-hmm. This document is going to now offer this protection around these assets. So during your lifetime, all right, because it's still to maintain complete control of all your assets, you're not going to be able to get that same asset protection during your lifetime. This is okay, all right? We're going to do there are other ways and other planning strategies we can employ for you in that regard. However, when it then goes to your children, this is kind of a unique benefit. It goes with trust and with this estate planning strategy, is it allows them, on the other hand, to maintain complete control of the asset while having it in the safe, protected. And they're the only ones, if you will, with the combination is a way to look at it. So they've got the assets in there. They can take out assets as needed. So if they need to take some money out to make a purchase, or if they need, like a vehicle or whatever it might be, or just for income needs, if they need to take money out for that, but they leave the principal in there, they let that continue to grow, and it's protected as long as they leave it in the safe. So again, even in divorce, even super creditors like the IRS or bankruptcy court can't get at that money. Only they can, and this is a tremendous value that you're providing. Retirement accounts, again, the same thing. That can be protected for them as well, so that they can reap the benefits of that on generations, for them, for grandchildren, even great-grandchildren and beyond, potentially, depending on the size of your estate and all the, and what kind of income needs are going to be. So this kind of planning can be tremendous, and this is another area when it comes, what have you done in regard to your planning? Have you got these types of considerations in there, not only for your lifetime, but then on to your children and grandchildren to accomplish your goals there? I do a lot, Russ, with people that are saying, I'd like to get, I want to do some legacy planning, basically. I want to make sure that my children and my grandchildren are going to be taken care of. And a lot of times it's just misconceptions, not knowing, for instance, joint ownership being one of those. Mm-hmm. Second marriages is another area. So we a lot of times get into this kind of planning where you have two people that have been married before, have children from different, their original marriages, or if you will. Now they're coming together later in life, getting married, and we do this, we talk about yours, mine, and ours now, this kind of planning. So why don't we address, this is another area of where you can take care for a couple, okay, we're running, this is a very common one, all right, where you've each got assets from before, all right, and maybe from where you were married, maybe you've been widowed, maybe divorced, whatever it might be, but now you've met someone and you want to marry, but you also have your respective children, and what kind of planning is involved there, it differs a little bit.
It does, because you've got different interests involved in the estate plan, and there is a different approach that we usually take to that sort of planning. Most of the cases we run into, the first spouse to die does want the survivor to have access and control over the assets that the survivor is getting from the deceased spouse. But then when the survivor dies, there's usually an agreement where they want to just split it between the separate families. My stuff goes my way, your stuff goes your way. And it takes some careful planning to be able to make sure that happens without any problems. I'm just going to throw out a couple things that we do for clients. We might recommend that at the first spouse's death, they peel off some assets and give it directly to their kids. Maybe do that through insurance. That way the kids aren't feeling like they have to wait till stepmom dies before they inherit something. Might be part of the retirement accounts. Again, this is an opportunity to kind of explore some of those issues. Second, when we're transferring assets to the survivor, maybe we're leaving them in trust like we mentioned before, but instead of the surviving spouse being the trustee and beneficiary, we might have a third-party trustee. That way the children can't badger the surviving spouse saying you're improperly handling mom or dad's money before we get it. Sometimes we set up that decedent's trust so that it's not subject to discretion. It's just taking a certain percentage and paying it out to the surviving spouse each year. So it's just a mathematical calculation at that point. You just figure out, let's say it's a 5% unit trust payout, you just figure out each year what's 5% of the trust worth, spouse gets that, rest stays in the trust. Therefore, no one can complain or moan and groan about anything. So we explore all of those issues going forward. Sometimes people have it so that, you know, they're just, at their death, they want it to go straight to their kids. And maybe the surviving spouse gets the joint assets or any other assets that they name the spouse as the beneficiary. So those are all opportunities to explore these issues and make sure that we get it set up ahead of time. I can assure you, if you don't have documents in place to take care of these issues, they're going to blow up. And I'm not kidding. We've seen some really nasty stuff come out of this, and you really want to sit down and take care of this while you're living and make sure you have proper documents in place.
This is one of those areas. In particular, it's just more complexities, right? We're just adding in some more things to be considerations for these situations. And this is where good planning comes in. The more complex, the more important the planning becomes. So if you've got this yours, mine, and ours kind of situation, how do you want that to look? And as Russ was saying, I can think of an example right off the top of my head. It was a couple, much like Russ said, where they basically came together. They each had respective families. They each wanted their assets to go to their respective families when they passed, but they also wanted to take care of each other. So they purchased a house together, and they wanted to make sure that the survivor of the two of them could stay in that house throughout their lifetime. And then when the second passed, that house would be sold, and that asset would also be divided amongst their respective families. All of these things can be done with good planning, all right? And they can be done in such a seamless way that no one's worrying, that the children aren't going to be fussing at each other. They're not going to be, one family's not going to lose out to, over another. All of this can be handled in such a way that keeps it fair and that your wishes are in fact followed through with. And when it comes to this kind of planning as well, there are other pieces that come into play. So whether it's the yours, mine, and ours, there's another area that is also handled with estate planning, and this has to do with what about periods of incapacity, disability, or maybe you have a special needs child. How are those things going to be handled? How can we put language in there to take care of that? We're going to answer that, but first a quick break. So join us here. We'll be right back on the Retirement Report.